Hi everyone, Keith Carlson here at Carlson and Jayakumar. I wanted to bring you a few more cases that we've been reviewing for the last few weeks, the middle weeks of November. First up has to do with PAGA and a wage and hour complaint. A lot's been going on with PAGA in the appellate courts. This one's called Rodriguez versus Lawrence Equipment. There, the plaintiff sued his employer for wage and hour violations and included a PAGA claim, Private Attorney General Act. It was ordered arbitration, and that coincided with the PAGA claim being stayed while the arbitration proceeded, which is a pretty normal procedure for that. The arbitrator ruled for the employer. The employer then moved for judgment on the pleadings as to the PAGA claim back in the Superior Court, arguing that the plaintiff didn't have any basis to serve in that capacity because his individual claims had been knocked out. The motion was granted with the court ruling. The court finds that plaintiff cannot state a cause of action under PAGA because plaintiff cannot state show any standing as an aggrieved employee following the arbitrator's final ruling that plaintiff failed to establish that he suffered any violations under the California Labor Code. And then the Court of Appeal affirmed that because Rodriguez lacked PAGA standing, as the arbitration showed there were no Labor Code violations. So essentially, arbitrator finds against the plaintiff on the individual claims, and the PAGA claim that was stayed in Superior Court, as a result, gets knocked out. Next up, an interesting case of wrongful termination, which is dealing heavily with the realm of social media and employees on private time. Warozinski versus United Airlines. A female flight attendant sued United for her being fired for having a social media account that showed in some pictures her in her United flight attendant uniform, and in other pictures her wearing a bikini and advertising a subscription account providing, quote, exclusive private content, close quote. This was in violation of United's social media employee policy. She countered that she'd suffered years of gender discrimination and harassment. The Court of Appeal ended up overturning the trial court's granting of a motion for summary judgment on United's behalf. It found that this social media basis for terminating her was improper, given that the plaintiff was able to show 3 male employees, both in uniform and sometimes partially undressed, on their social media, and she wasn't treated the same way they were. The Court of Appeals decided that the trial court needed to examine if the alleged comparators were actual comparators, so that'll go back down to the trial court for determination there. Next up, some civil procedure. First, in California, Capital Insurance Company versus Hoehn, the California Supreme Court overturned a long-time lower court of appeal precedent that a party had 2 years to move to set aside a void judgment or order under California Code of Civil Procedure, Section 473D, as in dog. Courts of appeal previously had used the 2-year requirement for such motions, but the Supreme Court recently found that there was no basis for that 2-year requirement in the text of the law, and if a case was based on lack of proper service, there was really too much risk to a defendant who wouldn't have had due process rights if they just imposed an artificially created judicial deadline that wasn't supported by the statute's own language. Another interesting civil procedure type case is Sheffield v. Kovtun. Kovtun was an attorney, or is an attorney, and had pled in an action against one of the spouses a statute of limitation defense because she had been countersued or countersuit and so forth. The attorney being sued ultimately made a statute of limitations defense because under CCP 340.6, attorneys being sued, you have a 1-year statute of limitation to bring the action. This was beyond that, but the attorney didn't raise the defense until 2 years into the proceedings, but had been bringing multiple anti-SLAPP motions. Ultimately, it was 2 years after this statute of limitation defense was asserted, and the Court of Appeal found that was waived, as it should have been brought initially in the response. Could have been done along with the anti-SLAPP motion, but not only after the anti-SLAPP matters were decided. So a couple somewhat wonky but interesting civil procedure matters, as well as a little bit more interesting for employers, PAGA and social media cases involving wrongful termination. Thanks, everybody. Have a great week.